and they occupied the classroom, that the votes were placed inside the Nissan van, which was left unguarded outside, and he believed that they could have been interfered with. He said that by that time he had been handcuffed on the instructions of CS Rocco, and some agents had run away. In his affidavit, PW6 could not confirm what happened at the voting in the classroom, as he was seated at the back observing. In his oral evidence, he reconfirmed that it was about 5 p.m. when the fire broke out, as the PO was attempting to light a gas lamp. That bedlam then broke loose, and the crowd of people started coming into the polling station. A video named NNK23 Collection Gitiburi was shown. He said that the crowd comprised of about 300 people, and at the time the ballot boxes were still in the classroom where they were left when the fire broke out. He further stated that locals salvaged the ballot boxes and took them to the vehicle, that the PO and DPO were not in the vehicle when the ballot boxes were taken to it. IEBC officers were called to come and collect the boxes from the vehicle, and they complied and picked the boxes. On further cross-examination, PW6 stated that there were things taken outside the polling station classroom by strangers. He said that he did not see in the video the ballot boxes being carried out by locals to the vehicle. Upon viewing the aforesaid videos, the court noted that as follows: there indeed was a fire, that there was commotion at Gitiburi, that there was involvement of large crowds of people, some armed with sticks, that there was also a van into which some IEBC officials in IEBC reflective vests were seen attempting to enter. However, no ballot boxes were seen in the videos. Hence, the videos do not support the allegation of third parties handling, I'm talking about handling, the ballot boxes. In his affidavit, PW7, Simon Kariuki, a voter at Gitiburi, stated that shortly after the fire was controlled, CS Rocco came to the station accompanied by people armed with sticks and rungus, and they took the ballot box to the vehicle whilst beating people. That CS Rocco demanded that the ballot boxes be brought to one classroom and ordered that the ballots from both Gitiburi 1 and 2 polling stations be counted together. One of the ballot boxes emerged from amidst the crowd and was given to CS Rocco, who gave it to IEBC officials. That CS Rocco demanded that the votes, that the votes be counted and tallied. He did not witness reopening of the ballot boxes again, and he denied signing forms 35A. He stated that the counting took place in one polling station at Gitiburi. RW4 Jane Karim Induma was a presiding officer at Gitiburi 1. It was her evidence through her affidavit that after the polling ended at 5 p.m., she secured the room before counting started. She confirmed that CS Rocco came to the station and caused commotion. She noted that there was a fire at Gitiburi 2, that she prepared the polling station as a counting room. She made no mention of Gitiburi 2 in her affidavit. In her oral evidence, RW4 testified that there was a fire at Gitiburi 2. It led to a commotion because there was a large crowd of people. She took the ballot box and took cover in a vehicle. That vote counting started at 7 p.m., that the votes for Gitiburi 2 were also counted at Gitiburi 1. In cross-examination, she stated that she did not see CS Rocco and that he was not involved. She admitted that she hosted another polling station and that no one authorized her to do so. When shown a video of the fire incident at Gitiburi, RW4 confirmed the incident was as depicted in the video. By that time, she said she had secured the ballot box in the vehicle. She said no polling officer for Gitiburi 2 was in the vehicle, but the boxes for Gitiburi 2 were there. On re-examination, her evidence was that after getting to the vehicle with her ballot box and with the security officer, she realized that she had left some personal items in the polling station. She thus left the ballot box in the vehicle to get those items. That was the only time she left the ballot box unattended. RW3 Lydia Kamau was the PO for Gitiburi 2. In her affidavit, she stated that after closing the station, she closed the KIMS and sealed the aperture at 5 p.m. She then called for a short break before counting began. At around 5:30, her deputy, Felix Mwaniki, lit a gas lamp which burst into flames. She managed to secure the ballot boxes. She telephoned Siakago police station and reported the incident and was issued with an OB number such and such. She stated that CS Roko came to the station and that his arrival caused some commotion. RW3 further stated in her affidavit that during the brief incident of the gas lamp explosion, the election materials remained secure. Let me read that again. RW3 stated that when the fire broke out, she took the boxes to the vehicle hired by IEBC together with the security officers and agents. She said that she and her team transferred their materials to Gitiburi 1 to count ballots, and they found Station 1 already going ahead with counting. In further cross-examination by Mr. Ndegwa, she stated that the forms which were burnt were KIMS Forms 32A. From the DR scrutiny report of 17th April 2026, the DR noted that the PSD for Gitiburi 1 recorded the fire incident as follows. Incidents recorded on page 30 as an accidental fire in Station 2 at 17:30 hours. Fire was put out and calm restored. Security backup. In Gitiburi 2, the PSD indicated that the PO recorded gas cylinder exploded and some of the forms were burnt. We were able to secure the ballot papers, ballot boxes, KIMS, and some forms. It is clear from the totality of evidence adduced that in Gitiburi 1 and 2, polling had concluded by the time the disruption arose from the fire and the crowd that invaded the polling stations. That RW4 took cover from the crowd in the vehicle, and at that time the boxes from Gitiburi 2 were in the same van without any officer from the polling station. It was admitted by RW4 that at some point she also left the box for Gitiburi 1 in the van unattended when she left to get her bags which had been left inside the polling station. With regard to evidence on Kaungu, RW7, Paulino Nthiga Njeru, the PO, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. He then stopped the election process for 30 minutes. When he reopened, voting continued, but the vote turnout was lower than earlier. He recorded in the PSD that locals and some politicians disrupted the polling process when some windows for the polling station were broken. Voting was disrupted between 13:45 and 14:15 hours, and action taken was the aperture was sealed at 13:45. All election material and officials were put under tight security. Thus, for Kaungu, it was the actual polling that was interrupted at 1:45 p.m. and the polling station was closed for 30 minutes. However, there is no evidence that during this time the election materials were removed from the polling station or were outside the PO's control. In summary, the evidence on this issue, we are looking at the issue whether there was broken chain of custody and lawful handling of election materials and violation of procedure of close of polling. In summary, the evidence on this issue is as follows. 1, at Kaungu, despite the fact of disruption of polling, the election materials were not interfered with. 2, at Gitiburi 1, the disruption occurred after closure of the polling station at 17:30 1730 hours as recorded in the close of the polling. Number 4, at Gitiburi 1, the evidence is that the election materials were left unattended in the van, according to the PO. 5, the evidence concerning the election materials at Gitiburi 2 is inconsistent, namely that they were handled by unauthorized persons and also that they were left unsecured or unattended in the van, or that they were secured. It is not clear. The evidence is inconsistent. From the DR's supplementary report dated 22nd April 2026, the results in Gitiburi 1, as recorded in the PSD, Form 35, and KIMS, were consistent, save for one ballot paper marked in favor of the fourth respondent with no corresponding counterfoil. For Gitiburi 2, the report shows that the KIMS kit showed that the last voter was verified at 16:55 hours, while the PSD indicated that the polling was closed at 1700 hours. There was one ballot cast in favor of the fourth respondent, but no corresponding counterfoil for it. The totality of the above evidence discloses that for Gitiburi 1 and 2, there was broken chain of custody, possible and lawful handling of voting material, but no violation of poll closing procedure. For Kaungu, there was no evidence of broken chain of custody, unlawful handling of or violation of poll closing procedure. Consequently, there is no basis for finding that the irregularity or non-compliance was substantial and that it affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, and occurred during the polling, a positive case would have been made to conclude that the violence affected the overall quality of the election and had a significant effect on the result. Issue number 7, whether there was use of state resources, state security, and public office to influence voters, which constituted abuse of power and improper influence in violation of Articles 10, 73, 75, and 81E of the Constitution under the Elections Act. The petitioner's complaint of the use of state resources, state security, and public office to influence voters was, from an evidential standpoint, entirely contained in allegations. I have carefully perused all the evidence that was adduced with a view to identify concrete evidence concerning the use of state resources, state security, and public office to influence voters. I have not found any. What I find in this case is that there is evidence that CS Roko, together with Embu Governor and other public officers, were mentioned by witnesses as intimately involved in the campaigns leading to election day. It is probable, but not proved, that these officers were using state vehicles or state resources for transportation during the election period. They may also have used state resources such as police personnel. There is clear evidence that enhanced police presence was noted by many witnesses. That is also clear from the videos played in court, where in some cases, vehicles with no number plates were seen. It is also likely that by virtue of the power, stature, and influence of their public offices, these officers could readily command attention of or influence voters. No evidence, however, has been adduced concerning actual abuse of office and improper influence by any particular state or public officer. It was incumbent upon the petitioner, in order to prove issue 7, to provide. The petitioner failed to provide these through the evidence adduced, and accordingly, I am unable to find in his favor on this issue. Issue number 8. Whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. With regard to delay in counting votes, the only evidence presented related to Gitiburi 1 and 2 were the breakout of the fire affected the timely counting of votes. Regarding exclusion of agents, the only evidence was that of PW6, who alleged that he was handcuffed and detained in a police vehicle. Until 8 p.m., hence was denied a chance to witness counting of the votes. From the DR scrutiny reports, agents of the petitioner were present in the stations where scrutiny was ordered, and they signed Forms 35A. With regard to defective and falsified statutory forms and opaque counting and tallying, the allegations in the petition were that Forms 35 were overwritten, resulting in opacity of results. In respect of Kerie Polling Station 2, Nazario Mugo, who was the PO, did not testify on the inconsistencies between Forms 35A and 35B, showing a total number of votes obtained and cast as 225 and 223, respectively, a difference of 2 votes. I looked at the form carefully, the Forms 35. The tally on the right-hand side for each candidate is indicated as in a total. That figure is supposed to be translocated to the column on the left-hand side, and the two should tally. So the key figure that is of interest is the one on the right-hand side, not the translocated figure. In respect of Gitiburi 2, RW3 Lydia Kamau, the PO, did not testify on the inconsistencies between Forms 35A and 35B, which indicated that the number of valid votes obtained and cast is 261 and 262, respectively. However, during scrutiny, the votes were recounted, and the number of valid votes cast remained 262, meaning that Forms 35B was erroneous by 1 vote. In respect of Mushonoke 2, showing 3 votes, scrutiny was not done for this station, and the inconsistency of 1 vote remains unexplained. At Kamugu Polling Station 2, Form 35A indicated, which is where the tally for each candidate is indicated. Whereas in the section of polling station counts, at item 5, the total number of valid votes cast is indicated as 456. This is on the left side of the form, 35. And the total rejected votes are indicated as 7. Shadrach and Nyaga and Jagib, the PO at this polling station, did not testify, and no further explanations were made regarding this inconsistency of 449 and 456 votes. On this latter inconsistency, it appears likely to the court that the 7 votes difference is attributable to the total rejected votes being carried to item 5 and added to the votes obtained. These unexplained inconsistencies in these votes, all these Forms 35 that I've referred to, these unexplained inconsistencies, I should say, add up to 10 votes in Forms 35. Add up to 10 votes in Forms 35A, a difference of 10 votes in Forms 35A and 35B, so that the election result has a 10 vote difference, unknown as to whom those votes would benefit. The scrutiny did not find anything to suggest any irregularity, but rather careless mistake in translocation from the vote tally column of Form 35. Form 35A. Regarding allegations that some 37 Forms 35A were overwritten and not countersigned, the court allowed scrutiny of only 8 of them where such overwriting demanded scrutiny. The DR's scrutiny report, dated 17th April 2026 at pages 21 to 24, found that despite overwriting, the figures added up to the total valid votes as in Form 35A. There was no major discrepancy noted. The court agrees that the overwriting did not result in any discrepancy and the irregularities, errors on Forms 32 in respect of assisted voters. I have had to deal with this issue because it arose during evidence repeatedly. At the outset, it is essential to note that the issue of assisted voters was not pleaded, either in the petition, in the petitioner's issues, or in the grounds of relief. It featured, however, in the supporting affidavit of the petitioner. In one paragraph, we'll get there, and in some of the other affidavits of the petitioner's witnesses, and also in witness testimony. In paragraph 94 of the supporting affidavit to the petitioner deposed as follows: that further, the said agents would bribe the voters on condition that they declared that they were illiterate and in need of assisted voting. This led to exhaustion of oaths of secrecy forms due to inexplicable influx of persons allegedly in need of assisted voting. The second respondents filed an affidavit in support of the response to the petition. The first to third respondents did not respond specifically to the allegation made under paragraph 94 of the supporting affidavit of the petition, even though on their behalf the second respondent acknowledged as follows: that I have read and been explained to by Charles Benedict Mongela, counsel on record for the first, second, and third respondents, the election petition dated 22nd December 2025, and the affidavit in support of the election petition, sworn on 22nd December 2025, by Dwiga Newton Kariuki, and wish to respond as follows. So the issue became sort of subsumed through the affidavits. In furtherance of his claims on assisted voting, the petitioner, during his testimony on numerous occasions, reiterated his claim on bribery and assisted voting, which featured in his supporting affidavit. Other witnesses of the petitioner, for example, PW10 and PW11, considered that as they were accepting bribes, others in the group and in the premises at the house of Edward Njage, where they were also accepting bribes to become assisted voters. PW9 Julieta Kidhumbu testified that she saw many assisted voters at Muchonoke Health Center 2 polling station, where she was the agent. She said that there were mobilizers who brought assisted voters to the station. In one case, she saw an assister explained to the PO but did not record the fact in her notebook, though she signed Form 35A without objection. The issue of assisted voters became pronounced after the court ordered that election materials be preserved into the custody of the court, and the DR to make a detailed report on the movement. That's the movement of the materials. The record of that movement of materials for preservation is contained in the DR's report pursuant to the directions of the court, dated 15th January 2026, for removal of the election materials from IEBC to Embu High Court. The report is dated 27th January 2026. In it, the DR recorded having received the following boxes from a strong room of IEBC offices in Embu. 134 ballot boxes, namely one from each polling station. One box captured as the 135th ballot box delivered at the tallying center. 4 boxes recorded in an, quote, inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, unquote. And finally, 15 boxes containing Kim's kits. Of the 4 boxes in the inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, that was box number 114337, it contained, amongst other things, 1,072 Forms 32, declaration of secrecy, made by a person assisting a voter. Naturally, this inventory raised concerns as to why these materials were produced from the IEBC offices at Embu without any record by the returning officer. Accordingly, in its ruling, paragraph 62 and 4, 62.2 and 4, delivered on 27th March 2026, the court ordered scrutiny of other strategic materials issued to Embu High Court. Following scrutiny by the DR, she reported her findings at page 15 to 19 of her report of 17th April 2026 as follows: that there were 1072 Forms 32, folio marked 1 to 1072. Out of these, 10 were blank or unpopulated in any way, blank forms. There were forms by 6 declarants which had filled forms, not which, by 6 declarants who had filled forms twice, of whom 2 declarants filled 2 forms at 2 different polling stations, while the other 4 declarants each filled 2 forms at 1 station. That is all contained in table 4 of that report. RW1 testified that at the tallying center, he received 134 ballot boxes. He also stated that he handed over to the DR 135 ballot boxes, with 1 box containing strategic materials. He stated that he prepared box 135 out of good faith. On the one hand is the cardinal rule on adversarial litigation, that parties are bound by their pleadings, ensuring procedural fairness, certainty of issues, and protection against trial by ambush. On the other hand, there is the constitutional duty imposed on election courts to safeguard the integrity, verifiability, accountability, and transparency of elections under Articles 86 and 81 of the Constitution. It is a substantive rule of adjudication that pleadings have a binding force. In IEBC versus Stephen Mutinda Mule and others, the Court of Appeal stated in unequivocal terms that parties are bound by their pleadings and that evidence which departs from the pleaded issues goes to no issue and must be disregarded. The same logic was reiterated in Raila Odinga and 5 others, Supreme Court petition number 5 of 2013. There, the Supreme Court emphasized that parties are bound by their pleadings and evidence must be confined to pleaded issues. Similarly, the Supreme Court in Zachariah Okoth Obado and Edward Oyugi, Supreme Court Petition 37 of 2014, reinforced the position that election petitions are strictly framed disputes. Respondents are entitled to know with precision the case they must meet, and the court is equally constrained by the issues framed in the pleadings. This establishes pleadings as the primary jurisdictional boundary of electoral adjudication. Against this strict framework, the Supreme Court in Gatirao Peter Munya versus Dixon Mwenda 2014 set out the governing logic on scrutiny, which is that scrutiny is not a fishing expedition. It is a verification mechanism tethered to pleaded allegations. The court was clear that scrutiny cannot be used to discover new causes of action or to sustain a petition that fails on its pleaded grounds. However, the court also recognized a controlled opening, namely that where scrutiny is properly ordered, particularly by the court itself, as in this case, what emerges may be interrogated by the parties and evaluated for its impact on the integrity of the result. Can courts therefore ignore serious electoral irregularities that emerge from scrutiny? Where scrutiny is triggered by a party's application, its scope is strictly confined to the pleaded issues and the specific polling stations in dispute. It cannot be used to enlarge the petition or introduce new grounds of challenge, as several cases cited. By contrast, where scrutiny is ordered suo motu, which is, I think, what this court did, the court may direct scrutiny as part of its case management powers to clarify the evidentiary record, but this does not expand the issues for determination or convert scrutiny into an inquisitorial process. Any irregularities emerging from the scrutiny remain subject to contestation by the parties and must be evaluated within the pleaded issues and the constitutional standard of electoral compliance. The question whether the court should turn a blind eye on malpractices arising from scrutiny was focused on in the Musikari Combo case, 2014, where the court held that an election cannot turn a blind eye to serious electoral malpractices revealed during scrutiny or recounts simply because they were not pleaded. The court justified this exception on constitutional grounds that electoral justice cannot be reduced to procedural technicalities, where the process itself is shown to be fundamentally compromised. In Peter Kingara versus IEBC 2014, the Court of Appeal emphasized that scrutiny is not an avenue for building a new case. That position was reaffirmed in many other cases, and I've cited a number of them. The courts have reiterated that scrutiny must remain tethered to pleaded issues unless exceptional procedural safeguards exist. That caution was emphasized also in Walter Nyambati case, 2018.